May it please the court, Tom Gonzalez for the appellant city of Tampa. And the starting point for this appeal is the collective bargaining contract.
Let me just ask you a question, though. You're going to reserve some time for...
Yes, sir. 5 minutes.
5 minutes? Okay. Thank you, sir.
The starting point is the collective bargaining agreement in which the PBA retains the exclusive right to appeal, not simply to control, but the right to appeal. And of course, it goes without saying that when they use the verb retain, it can't...
Can we back up a moment here? Our review, we're reviewing, this is an final agency action that we're reviewing.
Yes, ma'am.
Right? Okay. So what is our standard of review in order to reverse the PERC's opinion?
Whether it's supported by substantial competent evidence and is in accordance with applicable law.
Okay. And so there's been the issue of the arbitration and the arbitrability, procedural arbitrability. The final order states that that was an issue that should have been decided by the arbitrator.
Yes, ma'am.
And I understand your position is that no, it shouldn't have been because there was no notice given by the PBA to the city. So help me understand why this decision shouldn't have gone to the arbiter first before the city just said, no, we're not going to arbitrate at all.
And Judge, thank you for that question, because I think it encapsulates why the city is here. The city didn't raise an issue of arbitrability. The issue that was raised was whether or not the PBA was in fact appealing this grievance, not whether it was noticed. The fact that the notice was mentioned was only as proof that the PBA was in fact not appealing this because it allowed someone else to appeal it for them.
And so in order for, and I understand you object as far as the notice issue that the hearing officer found, but if there's competent substantial evidence to the fact that the PBA did in fact appeal, then, or tell me if there's not.
There was not, because Judge, the only thing that they said supported the contention that they had appealed was this vote taken in April. After April, in July, the PBA wrote a letter to these two grievants and said, we're not going to pay for your attorney anymore. And you can do it on your own. And then most importantly, because I think it's
the phrase, though, you can do it on your own and we'll pay for the expenses, the transcripts or whatever it was. They were going to pay some expenses. But they didn't say, we're not going to do it, it can't be done. They said, we're not going to do it, but you can do it on your own. And while we're not going to pay for your lawyer, we'll pay your expenses.
Yes, sir. But that's the DeSantis versus Pembroke Park. That case says they can't do that. They can't have the right to appeal and then unilaterally decide we're not going to appeal it, but we're going to allow you to do it. And if you read the words of the settlement agreement, that both of these
DeSantis is different from this case. The PBA in that case didn't go seek a motion to compel the arbitration. Isn't that a key point of distinction in DeSantis and then in this case?
I don't think it is for this reason, Judge, because in this case, and I think I start with the words of the president of the PBA. When she was asked, did you ever tell the city that the PBA was in fact appealing this? And she said no. And when she was asked why, the transcript is clear in saying, I didn't want the PBA's name associated with it. I didn't want the city to know that the PBA was appealing.
Well, wasn't she really saying she didn't want publicity on the matters that Mr. Purcell was choosing to publicize?
No, ma'am, what she's...
Was it that she didn't want the PBA to appeal at all, or she didn't want the publicity around it?
I didn't want my name or the organization to suffer being attached to something that was going to, I don't know how to other way to say it, piss off the chief or anybody else to where it would end up costing my members. If the PBA was in fact appealing, there's no way that the city couldn't figure out that this was happening. But it was the release that says, the release uses the words, we're going to let you use our process. And the DeSantis case says you can't do that. And with respect to the getting back, Judge, I haven't forgotten your question, with respect to why
Why that issue, yeah.
why the motion to vacate is, what wasn't at issue in this case was the city never had an opportunity. They never had an opportunity to deny the grievance because they never knew that the PBA was in fact appealed.
What about waiver, though? There was a whole lot of water over this dam from the time Mr. Purcell sent his letter, basically say, we want to appeal to arbitration. The city didn't raise any of the issues that you've raised now. Everybody began to prepare for arbitration. Everybody was kind of moving forward to it. And the thing seemed to fall out of bed over the lawyers arguing how much time was going to be needed to actually hear the arbitration. And after that occurred, after a lot of time had passed, then all these issues began to be sort of dug into. Isn't there a substantial waiver argument to be made for this?
There's no waiver, Judge, because the city did not know that the PBA was appealing
How
at
did
the
the city
time.
not know? Their lawyer, I believe was you even, was engaging with opposing counsel on doing all the pretrial stuff necessary.
Because, Judge, in three cases before, the PBA had not supported an appeal of a grievance. And in all those cases, the city agreed to let those people do it on their own. And the price of that is that the PBA wasn't there. The PBA never testified on behalf of those people. And the city was able to say, Ms. Arbitrator or Mr. Arbitrator, the PBA is not here. And we won all those cases. That wasn't the case here because
You're complaining then that you weren't able to strategically argue that the PBA wasn't here?
yes. Yes, ma'am. Because that's what when you read Galbraith, the reason that you have the union having the exclusive deal is that they make the tough decisions to say, we're not going to support you. And that's a tough decision that can open up the union to potential liability. And the city was always glad to say, we'll help you out.
And so when the city objects, I think it's a December letter, I think it's your letter, it says timeliness, and I'm shrinking it down to the bare bones, timeliness and notice. And that's the issue that the hearing officer focuses on, is timeliness and notice, and says, hey, you weren't supposed to just cut off the grievance procedures for arbitration. You were supposed to let that issue be decided. And that's why they found unfair labor practice.
Judge, if that is in fact the case, then where does the city get to argue that the PBA did not in fact appeal? If that was going to be a question for the arbitrator, then where was the entry point for the city to be able to have that arbitrated?
But I think that's what they were saying by that. They were following the analysis of Escobar, that these are issues you should have raised, you could have raised at the arbitration.
The issue of whether or not the PBA had in fact appealed? The fact
Whether or not
that,
they had filed a notice to appeal, because I think, well,
no ma'am,
your argument now is not what was raised initially on the objection.
Judge,
Because I don't think DeSantis comes in until later.
And I do think DeSantis is a different case, which I'll get to in a minute, but answer her question.
yes, sir. But with respect to what was raised, it was always raised. That's what the conversation that was just referred to between the attorneys as to whether or not, in fact, the PBA was appealing. That was always the basis for the objection. That's where the objection came up. It was always that.
Well, then you take this, we're in this substantial competent evidence analysis, right? Did the city know that the PBA was appealing, however they were appealing?
Judge, if that's the case, then what I hear the court saying, if that's going to be the approval, then at the arbitration, the city will be able to litigate whether or not, in fact, the PBA did in fact appeal this case? Because I don't see how that happens when we didn't ever have the opportunity to raise it in terms of thing. And
I'm not sure I understand.
Wasn't that evidence that put before the hearing officer, and the hearing officer didn't agree?
yes, ma'am, which means that the hearing officer decided an issue that he then said should have been decided by the arbitrator.
Well, I understand that point, and that's a question I'm going to have for your opponent here. But yes, I understand that. But we are stuck with that, okay? And so why was, and I know, I think you've already answered my question on this, so I'm not going to ask it again as far as the competent substantial evidence. But go ahead.
Judge, I guess the only answer I can give is if in fact that is an issue that can still be raised in arbitration, then I don't know that there is a basis for overturning it. If that remains something that the city can raise and can be litigated, then I understand what the rationale would be. I don't understand the rationale of PERC deciding an issue and then saying that issue should be raised before the arbitrator when there was no opportunity to raise it. And with respect to the fact that it had been done before, it had never been done before without the permission of the city. And that's what was done here.
One of the things that has troubled me about DeSantis and this case is in DeSantis, the union apparently, based on an affidavit, did not support the appeal to arbitration. Here, that we don't have those facts. Here, the union did support it, but they decided they didn't want to handle it personally, or they didn't want Jeff Stahl to handle it personally, because there was a way that, an interview was handled with a reporter that made people nervous or uncomfortable, so they wanted to distance themselves from it. It's not because they said, we don't think this should be appealed. We just said, we don't really like how you're doing it, and so we don't want to be involved in that. And it seems like DeSantis is really tied on these facts that, yes, it does say that they can't delegate the authority, but it seems to be based on the fact that the union took the position they didn't think this was appealable. And that's why they said, go ahead and do it on your own if you want to. So I don't know that this is going to be terribly difficult to distinguish this case. And I might also point out, we're not bound by it anyway. It's a fourth ECA case. So, but this is a different case. This case, clearly the union supported the appeal to arbitration. They just didn't like the way Mr. Purcell had gone about handling a reporter.
Judge, that's what the testimony is, and I will grant that this court is stuck with that testimony, which I contend is absolutely false. But be that as it may, the agreement and general release that was signed months after this supposed vote to take it to appeal says that the releasor acknowledges that the releasee contends the releaser has violated the terms and conditions upon which releasee filed the grievance on behalf of the releaser. And it agreed not to interfere with the strategy that these grievants wanted to take, and got a release of their liability. And if that's not the same thing as saying we're not taking this thing the way you want to do it, President Portman testified that they thought that there ought to be some kind of discipline. These grievants are saying there shouldn't be any kind of discipline. So with respect to the merits of this case, there's nothing to suggest that this union ever intended to go forward. There's not even an obligation to appeal it on the part of the grievance.
Other than the testimony of Ms. Portman.
I'm sorry?
I said, other than the testimony, I believe it's Ms. Portman.
Yes, ma'am. Which runs into the release that she signed. And by the way, extracted a promise that the grievance wouldn't tell the city or anybody else that they had signed it. Thank you.
Okay. So when you come back, Mr. Gonzalez, you'll have 5 minutes.
Thank you, Judge.
May it please the court, Luke Newman on behalf of Appalachia Tampa PBA. Let me start out by saying some good things about my client here, which I think is important. There's this idea that the city has put forward, my colleague who represents the city today, that these releases were entered for some nefarious, under the table, cloak and dagger type reasons. I want to be clear that my client is a labor organization, has a duty to its members of fair representation, sometimes called good faith representation. And so my client was in a position where its members wanted to proceed through the grievance process and then eventually to the arbitration process, which is separate and importantly separate based on the language of the collective bargaining agreement with their own attorney, an attorney of their choosing. And so my client gave its blessing for these members to proceed through the grievance process and through arbitration if they were terminated, and also gave its blessing for the members to do so with the attorney of their choosing. And I want to be clear, because we're obviously on a record here today, that my client entered into these releases so that if these two members then came back later and said, hey, you didn't fairly represent me, you didn't give me an attorney, I had to get my own attorney, that my client would be protected for any after-the-fact blame that might have sprung forth if they were unsuccessful in arbitration or through the grievance process through which they proceeded with their own lawyer.
Can you answer the question for me, that Mr. Gonzalez and I were talking about, the issue of whether PERC had the jurisdiction to decide the issue of whether or not the PBA appealed?
Was that, and I don't,
Well, okay, so the objection from the city was timeliness and notice, okay? And that was the issue that the hearing officer decided, and then went to step 2 of the legal analysis. And so I guess in the hearing officers and then PERC's final order, it says that the issue of whether or not the PBA appealed, that was like procedural arbitrability.
Right.
Is the word that they used.
correct.
And then they decided that issue. Did they or
The
did
PERC
they
hearing
not?
officer,
Yes,
I think
that's
that
my question.
that's my understanding, and I didn't mean to cut you off, but that's my understanding that when the city keeps calling this an objection, like we objected to arbitration, it wasn't really objection. I'll refer to the record to my colleague's letter. An objection was to say, hey, I object, this is improper. It was, no, game's over. We're not engaging with you anymore. So to call it an objection, I think is a little unfair. They said, we're not going to go to arbitrate. It's over. We're done. So it wasn't really an objection. They said, we're not going to arbitrate, and established arbitration law, including, and it's cited in the briefs in this case, authority from the U.S. Supreme Court says, hey, if you have a problem with the notice or the arbitrability of what's going on here, you need to raise that with the arbitrator. You can't,
And that's pretty much what the final order encapsulates, right?
I agree.
The hearing officer concluded that the city's reason, the PBA didn't itself give the notice of intent to arbitrate, raised a question of procedural arbitrability. That goes to the arbitrator. Because the prongs of Westfall were satisfied, we're done. There's been an unfair labor practice. Go arbitrate.
Certainly, that's my client's position. Absolutely. And so again, I guess I'm cutting off judges today. I apologize.
No, but the issue of where's the beef is the question that I have here. You know, what are the problems with having the arbitrator decide the question of procedural arbitrability? Because I'm not seeing it.
I don't see it either, and it's not my position to speak on that. And maybe my colleague who represents the city can speak on that, but I don't, to be
So in
told,
other words, I just stated your case for affirmance.
and I keep cutting you off while you're doing it. Yes, ma'am. Yeah, I apologize. But yes, I think we're in agreement there, that's how I see the case as well. So with that in mind, I also want to point out part of the city's position about this, that, I can stand up here for the entire 20 minutes and iron this whole thing out. But I think that we seem to be in agreement that the city's position has some obvious flaws here. And one of the things I want to point out is that they say, well, if the PBA, and this was discussed earlier, if the PBA doesn't appeal, they still engage. They have this historical practice where they engage in arbitrations, I guess, just out of the nicety of their heart. And then, but they like that because then they can bring us up and say, oh, the union's not here and we win those. But the other side of the coin doesn't work. And it's also I think it's kind of a circular argument where.
Well, we are, in fairness to them, we have an agreement and we have language in the agreement. And the language in the agreement is pretty specific as to what they're supposed to do and what they're not supposed to do. And the agreement doesn't read in your favor. It basically says that, that the union can't delegate this to an individual to appeal to arbitration. So, the only issue in my mind is whether or not they waive that provision by course of dealing, what they did, and or whether or not this really was them appealing through this privately retained lawyer who, while they weren't going to pay him, they were going to pay all the expenses. That's where it gets murky. That's where it gets difficult.
That's certainly my position, Judge. The second part of what you said is that, and I'll point out again, that there's been a contested evidentiary hearing with the PERC hearing officer where he took testimony, voluminous exhibits, and he came to the conclusion that that's what occurred. And to the extent that the city has a problem with that, I keep in briefing this and saying it's supported by competent and substantial evidence. And and obviously we're in an adversarial system here. So somebody wants to say, well, Mr. Newman, you don't have competent and substantial evidence. I keep pointing to these objective points in the record.
But it certainly would have been clear if the PBA would have sent a notice directly to the city that, hey, this is what's happening. Mr. Purcell is going to be proceeding, we appeal.
That might have been,
Clear.
that might have, in hindsight, have done away with the need to get to this point today. Yeah, I agree with that. But
Because unlike DeSantis, from everything I've read, that the PBA wasn't saying, we don't support this appeal to arbitration. And DeSantis, that's the distinction that I see. But I don't see any facts that support that here. I see that they just didn't like how Purcell handled that one interview. And they said, hands off, we're not gonna make the chief mad, and we're not gonna upset our 900 members, big fact that you guys are holding press conferences.
I agree with that reading of the record. And let me
And
discuss.
that's really why your client, and that's part of the reason why your client secured the releases, right? It was sort of hamstrung between allowing Purcell to continue to engage in sort of a media sideshow from their perspective, or depriving them of the counsel of their choice, right?
I agree with that. That's the position my client found itself in. And then let me go back to, and there's a couple points in this case in the record that this court has before it where you see my client having kind of a couple pans in the fire here with, they need to fairly represent their members. Okay, they can't just say, oh, you're a member, we don't like what you did. I mean, they could say that, but it didn't happen here. Be gone, good luck in arbitration. I think that's kind of what the city's insisting that they must have done, to the extent that that's the city's theory of the case. There's been a contested evidentiary hearing with exhibits and testimony, and they didn't prevail there. And so, let me go back, Judge Morris, and talk about DeSantis a little, because I want to say a couple other things. First of all, the city's reliance in DeSantis is newly found in this court. DeSantis is a 2002 decision from the 4th. The city was drafting and submitting lengthy objections and arguments that it submitted to PERC, and I'll be corrected if I'm wrong. But I didn't see, and I raised this, it's completely unpreserved. I didn't see the reliance on DeSantis anywhere in the voluminous legal argument that was submitted at the PERC level. So now they're coming here, first of all, and saying, DeSantis control, we're relying on DeSantis. Well, that wasn't raised below. And then secondly, I think,
It doesn't control anyway, it's merely persuasive.
I agree there that and then let me say something else, as gently as I can to the panel in DeSantis, okay? In that DeSantis case, where he's a fireman from Pembroke Pines, I think there might be some loose language in the DeSantis decision. And I'll point, Your Honors, to the dissent in that decision. And I ask you to focus on the dissent, I think it's Judge Pollan, where he kind of calls out the majority, the two judges, and says, I think we've gone a little, we've stretched this a little far afield here. And so I would suggest politely that the DeSantis majority decision says some loose language in there that it's not faithful to the holding in Galbraith, which is from 1984, Florida Supreme Court. If you look back at Galbraith, which DeSantis says controls, in Galbraith, the Supreme Court answers a certified question, and even in the text of that certified question, it says if the labor organization finds that the grievance is without merit. So then later on, we have a district court, two judges on district court panel say, well, that's neither here nor there, and it draws a dissent that kind of points that out, that this might be a little, we might have got to the edges of saying that has neither here nor there. If you look back at Galbraith, even in the certified question, it says where the labor organization determines that the grievance is without merit. So I want to point those aspects out, and I think we talked about it when Mr. Gonzalez was standing up earlier, that in DeSantis, the fireman there was this factual issue of does the union think his arbitratable grievance has merit, or does it not? And I don't think we really have that here. And to the extent that that the city says, oh, wait, we have that here, we have that here, this is without merit. It's like, okay, well, we've had a forum, we've had testimony, we've had exhibits, that we've gotten a determination, it's supported by competent, substantial evidence. I don't know what there is really to appeal on that level. There's no, in my view, there's no real argument, certainly not a persuasive one, that what PERC did is not supported by competent, substantial evidence. And I haven't heard a real illegal argument. You know, I realize that the city is relying today and in this appeal on the DeSantis decision, but I haven't heard a real legal argument that even if we were to look at what PERC did on a legal basis de novo, I haven't heard one that says that their legal position is somehow, you know, fatally flawed. I have not heard that. And so unless there are any more questions, I feel comfortable submitting the Tampa PBA's position on today's argument, my argument, and certainly on the appellate brief. Thank you.
Thank you. Dallas, 5 more minutes.
Judge, I want to start with the testimony about what Mr. Purcell did to cause the PBA to say, we don't like the way you're doing this. Purcell's testimony, which is cited in our brief, was that he had no idea what they were talking about. He said that he thought that Mr. Stoll had a conflict, and that's why he had to do it on behalf of them. It points to the fact that we're talking here about all these things that the city's going to raise, but Judge, the PBA isn't going to be at that arbitration to defend those positions. The PBA is going to take no part whatsoever in that arbitration. So what you're saying is that language which says that the PBA shall retain its exclusive right.
You mean in representing the grievance here? Because, I mean, you're saying the witnesses aren't going to testify?
I don't know of any that plan on being there unless they're asked to be there.
Yeah, your position is the PBA will not be there through council to advance its own.
Period. So there's not going to be anybody who represents the PBA.
Mr. Purcell would be there only to represent these
Period.
former officers.
So with respect to this thing that's supposed to take place in front of the arbitrator, I don't know who is going to put forth the union's position on all those issues in terms of what's still going on. The Galbraith case, I'm not the Galbraith case, but the DeSantis case was raised because what the hearing officer found, as I read it, was that by authorizing Mr. Purcell to give the notice, they were in fact appealing it. That's what they were saying. That's why it was raised. But leave DeSantis out of it entirely, Judge. You don't need DeSantis. There's contractual language that says the exclusive right to appeal, to prosecute the appeal to arbitration is with the PBA.
And you further have taken the position unless the county would agree or the city would agree, the contract binds them to be the only one that can do this.
And to carry out their duty to go ahead and turn down non-meritorious grievances and live with it, because there's not going to be an opportunity to say, well, Mr. Grievant, you can mitigate this by doing it on your own, and we'll let you do that. And I think that.
So if we disagree with you on that issue, okay, which is, I think the crux of your appeal here, then do you lose on the points as far as unfair labor by not participating and going through the process to arbitration?
I'm sorry, Your Honor, on what issue are you talking about? Maybe.
The crux of your point here is that we didn't have to arbitrate at all. But if we disagree with you because of the cases that we rely on, then do you agree that PERC's decision as far as the unfair labor practice was correct?
In other words, the union is committed an unfair labor practice by not following through with this.
Yes, I think that's a truism. I think that has to be the case. I understand that. But then that still leaves the question as to when the city gets to arbitrate these issues that it should have arbitrated. And that's all I want to make sure we get that chance. Because I guarantee you we can put on that case and to prove that what happened in this case. But I don't know that we have an entry with the way that it stands now. And what I want to focus on now is the argument from the PBA about the duty of fair representation. I've never in my life seen a union extract a promise, a release of all of its obligations as part of letting somebody use an arbitration process.
I think there was another, the case doesn't come to me now, but I think there was another case in the briefing that there was a similar release that was done, but I can't remember.
Judge, I don't know that I remember it, but I will tell you that for them to argue that what they were doing was carrying out their duty of fair representation, if the only way they could carry out their duty of representation was to prosecute this appeal, and it's inconsistent to get a release of that obligation as the price of letting them do this.
Well, they were just, I mean, it's a release, they're protecting themselves by someone wanting to personally go with their own private lawyer.
Judge, that's unsupportable. That we've got the grievance, we've got the minutes of the board of directors. This wasn't these grievances come up and say, hey, we don't want to use Jeff Stahl anymore. This was done after the board of directors voted to send a letter saying, we're not going to give you an attorney anymore.
Mr. Gonzalez, you're out of time, sir.
Thank you, Judge.
You know, the Cooley lawsuit was left too soon. This was the main event. You don't get to see a case like this very often. This is a very unusual case. Thank you all very much for your efforts.
Thank you, Judge.
We have one more case. Do you want to take a break or press on? Okay, our final case that we have on the docket today is Arthur Pettish versus the Myakka Valley Ranches Improvement Association. And I will say this case also is kind of unique. So we've had some interesting cases today. Nothing's been ordinary today.
Before starting the argument, I was thinking there are similarities. It's like almost a class situation in both cases.